This panel is very much in the spirit. We have a great range of views, expertise, and here. And let's get right to it. We're going to begin with Mark Eckenwiler, Senior Counsel at Perkins.
All right. Thank you, Jeff. Thank you all for attending. I'd like to talk about, as Jeff hinted, one other side. I think it doesn't respond directly to PRISM, the Section 215 order, but something that's nevertheless been very much in the news and very much on the mind of Congress and the mind of industry over the last 3 years. That's ECPA, the Electronic Communications Privacy Act. In my 2 to 3 minute intro, what I'd like to do is cast you back to that golden year of 1986, when, and the years before that, when Congress found itself grappling with these astonishing new technologies like fax machines and pagers that could actually do something other than buzz in your pocket. They could actually transmit numbers. This amazing thing called a BBS, a bulletin board system, where you could post messages on a computer network and somebody else would read them and be able to respond politely or otherwise. And at the time, because of course these were extremely novel technologies, the legal status of both the communications themselves, and this is one thing I think will permeate all of our discussions today. There is in the law this fundamental divide in American constitutional law between contents of communications. We know this from a pair of Supreme Court decisions in the 1960s, Katz and Berger, and information that is not the content of a communication. So the simplest example of that would be numbers dialed to place a telephone call. And ECPA embodies that dichotomy. But when Congress was dealing with these issues in the mid-1980s, it was working in this area of profound constitutional uncertainty. And so it enacted what is in effect a gap-filling statute. ECPA provides this range of protections requiring various levels of showing from a simple subpoena all the way up to a warrant based upon probable cause for different kinds of information. But I think it's fair to say that now, these many years later, ECPA is starting to show its age. And one of the most obvious examples of this is that ECPA permits law enforcement to compel the contents of stored email, so somebody's webmail held by the service provider, with less than a warrant under various circumstances. If the communication is more than 180 days old, at least under the terms of the statute, that may be compelled by the government with a mere grand jury trial or administrative subpoena. The good news is that Congress has been looking at this closely. There's been a series of hearings, and on April 25th, the Senate Judiciary Committee, chaired by Pat Leahy, who was, of course, the father of ECPA back in 1986, marked up a bill which would impose an across-the-board warrant requirement for email. Just one other point, and then I'll stop talking here. The key thing to understand about ECPA, riddled as it is with all these dichotomies, prospective surveillance, historical records, content, non-content, is that there's yet another dichotomy in this framework. And the easiest way to think of it is that ECPA and FISA are like two tectonic plates. They are similar. There are places where they overlap. There are places where there are gaps between them. ECPA largely controls what is done by law enforcement. So those people with guns and badges who want to put people behind bars. They want to go have public proceedings, try somebody before a jury, and incarcerate them if they're guilty. FISA is about this entirely separate world of intelligence gathering, which operates, by definition, largely in the shadows.
Very helpful, Mark. Thank you so much. Next, we'll hear from Susan Freiwald.
Okay, thank you. So Jeff teed it up by asking about the Fourth Amendment, and I just want to say that the Fourth Amendment the Fourth Amendment contemplates that all three branches will have a lot to say about how the electronic surveillance is done by the executive branch. And when the founders originally passed the Fourth Amendment, they wanted to make sure that the executive branch did reasonable searches, but also that Congress passed laws that required reasonable searches. and that involved the meaningful oversight of the judiciary. And so I want to just briefly talk about how each branch is living up to the requirements of the Fourth Amendment. First of all, Congress, as Mark just told us, Congress has really waited way too long to update ECPA. And by the way, I urge you to look at ECPA. It's 18 U.S.C. 2703 is the stored communications provisions that we're talking about. They need to be brought up to date in the sense that there's inconsistent, they don't uniformly provide for a warrant for stored data, which as we now know is really important. And the Sixth Circuit required that under the Fourth Amendment, but many jurisdictions don't. Senator Leahy has a bill that would require that. Some people are trying to weigh that down with bad amendments, if you ask me, in Congress. Zoe Lofgren has a better bill, stronger bill, because it would also cover location data, which I will talk about next. So Congress has been falling down on the job, also because Congress passed the FISA Amendments Act of 2008, which arguably authorized the PRISM program that we'll talk about in a bit. Now, location data. Location data is the collection of data about where you've been using your cell phone records or GPS. And as many of you know, the Supreme Court last year found in the Jones case that the use of a GPS tracker was a search under the Fourth Amendment. So that was the Supreme Court actually getting in and updating, in some ways, the Fourth Amendment jurisprudence for the modern age. The Supreme Court left a bunch of questions unanswered, including what about cell site location surveillance? What about surveillance that doesn't require a trespass? Do we require a warrant or not? And I've done some research and recently published a paper that shows that the lower courts aren't answering those questions, because they are using a new exception to the good faith rule, which is the Davis exception, which says that if you have binding appellate case, and they're using it even more broadly than that, you can just say that the law enforcement operated in good faith and not even get into the Fourth Amendment question. So to my mind, the courts are kind of not getting in there enough to answer Fourth Amendment questions. An egregious example of that, of course, is the Clapper decision that you should go hear the panel tomorrow talk about, where the Supreme Court refused to look at the FISA Amendments Act. We're also waiting for the Fifth Circuit to decide whether location data surveillance of records, government access to records of location data requires a warrant, and I argued that as an amicus in October in the Fifth Circuit, and we're still waiting to hear. So waiting on the courts with the Fourth Amendment and new surveillance. So the only branch that's really effectively getting in there and just kind of, I want to say, making law in some ways, making its own law on electronic surveillance, as you know, is the executive. And I think that's not at all how it's supposed to work, and I think many of us would agree, and I certainly feel strongly that they've gone way overboard. And I know we'll talk about that more in questions, but let me just say that the FISA provisions that we need to talk about are the FISA Amendments Act of Section 702, which is 50 U.S.C. 1881A, and I encourage you, if you have a cell phone, just pull it up, because we need to talk about the provisions. And then the Verizon metadata program is under 215 of the Patriot Act, which is 50 U.S.C. 1861. So very briefly, I think the 215 section is quite clearly unconstitutional under the Fourth Amendment. I think the 702 section raises more difficult questions, but is probably unconstitutional as well.
You know what, just because you've mentioned it and it's crucial to our discussion, I'm going to ask you to tell us what the FISA amendments and Section 215 say, and why you think they're unconstitutional.
Okay, because my time's up.
I know, but we're going to have to talk about it eventually. You're being very good. Well, you know what? No, in the spirit of complete bipartisan even-handedness, you're right. Thank you for that review. Let's keep to our time limits, and then I'll ask you and all the other panelists to explain that as well. Thank you, Susan, for keeping me on the straight and narrow. Nathan Sales.
Thanks, Jeff, and thanks to the ACS for inviting me here. Happy to be a last-minute pinch hitter for my friend Jamil. I'd like to talk a little bit about programmatic surveillance, which is a type of surveillance that is familiar to many in the intelligence community, but those of us who are lawyers don't have a whole lot of experience with it. The type of surveillance that we're familiar with as lawyers is what we see on cop and robber shows, individualized, particularized surveillance, where you think Tony Soprano's up to no good and you ask a judge to give you permission to listen to his phone calls. In traditional traditional surveillance, you start with a suspect, and then you place them under surveillance to gather evidence that you use, ideally, to incarcerate, to prosecute and then incarcerate. Programmatic surveillance is entirely different, and in fact, you can think of the process as being exactly the opposite and reversed. We don't have a particular suspect in mind. Rather, we collect a bunch of data, and then we identify particular suspects, right? So the process is actually 180 degrees out of phase from the type of surveillance that we as lawyers are familiar with. What I'd like to talk about in the 3 minutes I have left, and in Q&A, so ask me questions, please, is some of the potential benefits of programmatic surveillance and how to do it in a way that respects privacy and rule of law values. So why should we do programmatic surveillance? Well, in part because it can be a very useful way of identifying unknown threats to the national security. There may be some law enforcement applications to programmatic surveillance, but I think we should save that for another day. An example of this involves passenger reservation data. It's actually really easy to identify links between known terrorists and their unknown associates by looking at passenger reservation data. There was a 2002 study by the Markle Foundation. I think one of our panelists actually participated in this task force report, saying that using basic passenger reservation data, such as names, phone numbers, street addresses, and so on, it would have been possible to identify the entire social network of the 19 hijackers that would go on to perpetrate the 9/11 attacks. You start with 2 hijackers who had participated in a terrorist meeting in Malaysia and were therefore placed on a watch list. Using basic information such as their addresses and phone numbers, it would have been possible to link them to every single one of the other 19 hijackers. Is it possible to do that in all cases? No, probably not. But there is at least enough potential upside to pattern analysis based on programmatic surveillance that I think it's something that we should keep in mind as a possibility. Why else should we do it? Well, another reason why we should do it is because it's inevitable. Programmatic surveillance and data mining already take place on a massive scale. Google knows a lot more about you than the NSA does. It's basically inevitable that as this technology evolves and becomes more commonplace in the private sector, it's more or less inevitable that the government is going to do it too. That's not to say that government use of these techniques raise the same privacy issues. I think government use of these techniques implicates much more problematic privacy problems. But the normative question is separate. As a descriptive matter, the government is going to be doing it. So what we need to do right now is think about how we can put the right restraints on the government so that when this programmatic surveillance does become more mature in the future, we're comfortable with the balance between security and privacy that's going to be struck. So how do we do it? This is the million-dollar question, and it's a million-dollar question that we'll have to save the elaboration for later on. But I think there's 2 different types of constraints that we should think about to limit government use of programmatic surveillance. One set of constraints concerns how do you set up the program? Architecturally, how do we build a programmatic surveillance regime? And then the second set of constraints has to do with the operation of a programmatic surveillance regime. What kind of constraints and oversight do we want on the day-to-day operations of the system? Just a few ideas that I'll throw out there for your consideration. When establishing a program, the architectural side, I have a very strong preference for anti-unilateralism. This shouldn't be up to the executive branch on its own. Congress should be involved, and to a certain extent, the court should be involved in the creation of the system as well. I also prefer an anti-mission creep principle. If we're going to have programmatic surveillance, it should be limited to finding terrorists and spies in our midst. We shouldn't be using it to track down deadbeat dads who are behind on their child support payments. I also want clear legal authorizations. Congress shouldn't be hiding elephants in mouse holes, right? If we're going to have it, we should have it clearly authorized in the law, not as a penumbral inference from other provisions that have been enacted. As far as actually operating the program, what kind of constraints should we have there? Well, programmatic surveillance is all about making it easier to collect data on the front end. So as a corresponding move, I think it's important to put more limits on the use of that data, right? So if we're going to make it easier to acquire it, the substitute is we're going to make it harder for you to access it. You can't just open up the database and trove through it at random. You have to have a good reason, and maybe some sort of court order requirement as well. We could talk about more requirements in the future, but those are just sort of a thumbnail sketch of what I think could help domesticate a programmatic surveillance regime.
Excellent. Thank you so much. And finally, Peter Swire.
Thanks, Jeff. It's great to be here. First, I want to tell you a story about a tough first week on a job for a friend of mine named David. He was sworn into a federal office a week ago on Wednesday. And last Thursday, the new head of the Privacy and Civil Liberties Oversight Board woke up to all of these things.
Wow.
And, it's like, wow, he thought he was going to, figure out how to, where to walk on the first floor. So, David, this is relevant to you all in the following way. David Medine is chair of this new independent agency in the executive branch. Now that he's chair, he's authorized to hire, which they previously weren't, and they have the other commissioners. And he is actively looking for smart young people who like civil liberties, privacy, and oversight to come work for him. And so if you're interested in that, he has asked to put out the word that you can simply write to Medine, MEDINE, PCLOB, Privacy and Civil Liberties Oversight Board, at gmail.com. So the Google will know about all this. So MEDINE. And he's looking in particular for two sorts of help. One is anybody who has a recent or current top secret clearance, because you could get, well, you laugh, there's such people exist. Over 500,000 we found out this week, right? And then the second thing is he's looking for scholars and residents or other people who'd like to dive in a longer term. So this is a chance to actually dig into these things. And if some of you are trying to figure out where to go next, write to David, and he's actively looking for wonderful people to work on that. And next I'm going to go back in a time machine, not all the way back to 1986, but to 6 weeks ago to the front page of the New York Times. Most of us can remember back that far. And the front page story was about the government was having a great deal of problem doing surveillance to such an extent that they were worried about going dark. I don't know, anybody see the going dark articles in this group? Not really? A few. Okay, so I'm going to ask you to imagine you're the general counsel of the FBI. And in the old days, if you served a court order on a telephone, you would be able to actually serve a court order to get Nathan's telephone calls, a wiretap. But today, if Nathan's using, let's say, World of Warcraft for his communications, which is not a standard phone company thing, there's no way necessarily that WoW will turn over those communications. And so the FBI is worried they can't get the contents of these phone calls. So what looked to be a game, my sons play World of Warcraft, to the FBI is a global terrorist communication network, right? Because this is how online you can do all these communications. And so the FBI and other parts of the government have been very worried that surveillance is collapsing. They won't be able to do their job, and they're going dark, that they're going blind. I have a little bit of sympathy for how certain things can't happen, but I've written that rather than going dark, the right metaphor is the golden age of surveillance. And so I have an article up there that you can look for golden age of surveillance. And this was written about 2 years ago, and it made 3 points. One is that today the government can track your location for the first time in history, because all of us carry these things, so now everybody has a tracking device. And we found out under the Verizon orders, apparently, that they are in fact keeping tracking records of your location when you make phone calls. So this wasn't hypothetical that they can do tracking, it's being collected. The second one was that a government has a great amount of information about your confederates and associates, who you texted, who you emailed, who you telephoned to, et cetera. And this same metadata sort of story shows everybody you called, and then they can figure out everybody they called or emailed or texted. And the volume of them, at least in my inbox, is enormously up over time. So the government has an incredibly dense web of your confederates over time. And then the third thing is other databases, and PRISM and other things show that they're looking at all sorts of other databases. So rather than it being hypothetical, that the government says they're going dark, but we say there's a golden age, we now have new information about really huge amounts of golden age of surveillance things happening. And I think that can put us in perspective of, roughly speaking, whether that going dark claim is very plausible. And I think the one other point I'm going to make, and we'll get into 215, et cetera, later, is some thoughts about how this happens in government. I worked under President Clinton as the chief counselor for privacy. One of my jobs was then Chief of Staff John Podesta asked me to chair a task force that Mark was involved in, among others, on how to update wiretap laws for the internet. And we came out with proposed legislation in 2000 as administration policy. So it was like, how do you really do this? And I think one thing I learned can help to answer a puzzle I've heard posed by some people. So let's imagine, if you will, that you had a con law professor, somebody who had spoken in public skeptically about FISA and foreign surveillance, who then got into a position of authority. And then, under that position of authority, did not actually cut back on the FISA surveillance. Well, that's President Obama, right? President Obama is a con law professor who had spoken publicly on quite a number of occasions about his worries about overreach of FISA. So how is it that his administration more or less maintains the 2,700 programs? I did not work on these issues. I was back in government this time working for Larry Summers, but I didn't work on these issues this time. There was a financial crisis going on, they said. But I'll give you some thoughts from having watched the 2000 process. And the thoughts have to do with federal clearance, where there's all these different agencies that have things, and where you stand in Washington depends on where you sit. And so the Commerce Department might be worried, about making sure tech companies can thrive, but the Justice Department really doesn't want their life being much harder. Most people in the Justice Department would like to be able to achieve their mission without having to hand in extra stacks of paperwork every time they do things. And the NSA wants to achieve its mission, and the CIA, et cetera, lots of three-letter agencies. So when you have a meeting of all these different agencies and they're putting in comments on draft proposals, the weight of the many agencies who are being regulated is great, and the number of people saying, but wait a second, civil liberties or whatever, there aren't as many people institutionally, not as many centers of power around the government whose job is to do that every day. And so one of the things that happens absent some huge push to overcome the objections of those agencies is stasis. And I think one possible reading of what we've seen on these issues under President Obama, again, I haven't worked on these issues to any significant extent on them, is that there probably were all sorts of people with instincts like the president's stated instincts when he was a senator. But the enormous pressure to overcome resistance from people who need it for their daily jobs, it takes a level of pressure that's really enormous. That pressure works better if Congress and the public and the press puts the pressure there, because that emboldens and enables the people who want to bring out the civil liberties side of the administration. But if that voice is not there to insist that the administration live up to its claimed views, then the bureaucratic reasons not to change become very, very powerful. And so now we're in a stage where we're having these debates. We're here today and all that. And I am an enormous supporter of the president on a million zillion issues. But on this issue, I think it behooves us to really pressure to bring out the civil liberties side of the administration that was elected and the Fourth Amendment that many of us believe in. And I think that actually enables the best sides of the current executive to come out.
Wonderful. Thanks to all for extremely concise and to the point and illuminating comments. Here's what I heard each of you say. Susan, you declared that the Fourth Amendment does require a warrant for the content of stored information, in your view. But Mark, you said that because the courts have refused to consistently apply that holding, statutory protections have not entirely filled in the gaps because of changed technology. ECPA has this outdated distinction between content and metadata. There are proposals to change that, but they haven't yet passed. And unless Congress actually imposes a warrant requirement for stored data, Susan, you think that that would raise constitutional issues. And then we have this broader question of whether what Nathan very aptly called programmatic surveillance is consistent with the Fourth Amendment to the degree that it doesn't require a warrant for the prospective accumulation of lots of data without suspicion. And Peter, you gave a really illuminating account for why this administration might be expanding programmatic surveillance. Let's now just get into the weeds and have a debate among ourselves about the legality, first of the Verizon program and then of the prison program. So Verizon, the relevant authority is 215 of the Patriot Act. As I understand it, experts correct me if I'm wrong, before Section 215 of the Patriot Act, in order to get a FISA order, you had to do two things: certify that someone was a suspected spy or terrorist, and two, you could only get particular kinds of data, like business records or car rental records. You couldn't get anything. Section 215 changed that in two ways. First, it removed the requirement that you had to certify that someone was a suspected terrorist. Now, all the government had to do was certify that the FISA subpoena was relevant to a terrorism investigation. And second, the category of data that could be seized was expanded exponentially. It had been limited just to business records. Now you can seize any tangible thing. Basically, you can get anything by certifying that it's relevant to a terrorism investigation. And yet even Section 215, according to its author, Representative Sensenbrenner, was supposed to apply to individuals or limited amounts of data, he said that the seizure of data prospectively on an ongoing daily basis of everyone went even beyond what he imagined, and therefore that the Verizon program, as he understood it, was inconsistent with Section 215. Mark, have I accurately stated the law, and can you give us your views about whether the Verizon program is or is not authorized by Section 215?
Jeff, I think you've hit the nail on the head, and I agree that this particular use of Section 215 is highly questionable for the two reasons that you identified. One thing to understand, and I want to go back, I know I've said this before, but I think it's really, really crucial to understanding the architecture of all of these statutes. They are built around the dichotomies that I described earlier. The two big ones under ECPA, and this is generally true under FISA as well, content, non-content along one axis, and along the other axis, are we talking about prospective acquisition or acquiring one-time data, basically snapshot versus making a movie. And what's curious about the use of this Section 215 order to collect for a prospective period, the order was good for a period of 90 days with some forward-looking language in it, is that FISA already has in it a pen trap provision. And for those of you who are not immersed in surveillance law, a pen register, certainly when the pen trap statute was enacted on the crim side as part of ECPA in 1986, the idea was this is the counterpart to wiretapping. So a wiretap order allows you to listen to, and let's just talk about the technology of the era, a phone call for a period of 30 days. It's the maximum allowed under Title III. A pen register order, typically used at an earlier stage in investigation, allows the government, allows criminal investigators to surveil a particular phone line, not to find out the contents of the communications, but rather who is being called by that target number or who is calling into that target number. So that's existed in ECPA since '86. There is a corresponding, there's sort of a parallel, a shadow provision in FISA for performing pen register, trap, and trace surveillance. So that's the prospective metadata collection tool, and I find it therefore passing strange that Section 215 would be used in the way that this order apparently was.
But it's more rigorous review in the FISA pen trap provision. The judge has to conduct meaningful review of the application.
I'm just saying structurally, it doesn't even, well, I mean, from a pure expediency standpoint, I could see why someone who wants to get this data might look to some other tool that's less demanding. But from a structural standpoint, it seems inexplicable to me.
In the spirit of the National Constitution Center, I'm hoping that we're going to have some disagreement here. Nathan, do you agree with your colleagues that Section 215, in fact, does not authorize prospective ongoing daily surveillance?
It's hard to say because we don't really know what the court's theory of why 215 applies here is. So what we have is the secondary order. The way FISA orders work is there's the primary order and then there's the secondary order. And you said get in the weeds. You asked for it. So the primary order is the order that applies to the government, and it says here are all the restrictions that you are bound by. The secondary order is a very short document that applies only to the telecom provider, and all of the stuff that we're most interested in. What's the theory of why this provision applies? What kind of minimization requirements does the government have to follow? Who is allowed to access the data? All that stuff that actually really matters from a privacy and civil liberties standpoint. We have no idea what it is. So I'm not sure I know enough about the government's theory of why 215 applies here to be able to venture an opinion on whether it's an appropriate reading or not. Let me address this question more obliquely. Why is the government using 215 instead of the pen register and trap and trace authority? Bless you. I think part of it has to do with the business models of telecom companies like Verizon. They don't warehouse this data for very long, it seems. And so the government thinks we want to have this stuff on file in the event that later on in the future we want to query the database. Well, if we leave it to the private sector, they're just going to delete the stuff because there's no business reason for them to retain it for long periods of time. So 215 is probably, in the government's mind, a better tool for gaining access to that than Pen Trap, which is more collecting this information in a real-time basis rather than historical archived data. That might be one non-bad faith reason for going this route. By doing that, however, the government has actually tied its hands. This is a counterintuitive point, so I want to dwell on it for just a second. The government has actually tied its hands in a way that it wouldn't have if it had used the Pen Register and Trap and Trace Authority under FISA. So the way the program works is it's a two-step process. The first step is obtain the 215 order directed at Verizon, directing them to turn over the records, billions and billions of call records. That data then apparently goes into a digital equivalent of the warehouse at the end of Indiana Jones, right? It just sits there, as far as I understand, right? Well, how do you access it? Well, later on, if the government uncovers information that somebody who just bombed the Boston Marathon used a particular phone number, they query the database. Who else has this person who used this phone number called? Are any of them on the Al-Qaeda watch list or so on? So what do you have to do at that second step to query the database? My understanding is that you can't simply open up the database and look, right? You have to have reasonable suspicion. The FISA court order requires the government to demonstrate reasonable suspicion to believe that the query will turn up evidence or not evidence, intelligence information related to a counterterrorism investigation. That is actually harder to do than to obtain a Pen Register or Trap and Trace authorization. To obtain a Pen Register authorization, you need to establish relevance, right? Because under Smith v. Maryland, the constitutional floor here is set very, very low. The reasonable suspicion standard isn't probable cause, but it is actually, it does have a bit more tooth. It has a bit more bite, right? So by structuring its surveillance authority under 215 rather than the Pen Trap statute, the government has actually bound itself in a way that is beneficial from a privacy and civil liberties standpoint.
So just so I understand this, on that point, the metadata is being collected under 215 en masse on an ongoing daily basis, but the government can only look at individual pieces of data by certifying that it's relevant to an ongoing terrorist.
I think that's right, but this is all intel. Peter mentioned active clearances. Mine aren't active anymore, so I don't know.
Peter, you are a lawyer to President Obama, irritating law professor hypothetical, but I want to put on the table the best argument on behalf of the president.
Oh, I've just been assigned to be that lawyer.
Yes,
okay.
you are. Yes, I'm assigning you that. Okay. The president said this is clearly consistent with the law. Congress has approved it, and the law is constitutional. What's the theory? If you're trying to imagine what those secret memos say, is it the claim that this is metadata and not content, and therefore they think that no particularized suspicion is necessary at all to get ongoing metadata perspective?
Well, I think the idea that the government only gets to, under the Verizon part, that the government only gets to see it if there's specific and articulable suspicion to get it. In the intelligence world, that's actually pretty strict. That's stricter than many intelligence standards are before analysts look at things. And so if you think the systems are working right and compliance is working right, it's overall reasonable under the Fourth Amendment because before any living person can ever do anything with it or find the Boston bombers Confederates, you have to meet a standard that's higher than has been required for lots of other things in the intelligence world.
And how would you imagine that specific?
Susan's itching.
No, we're just. The
I was assigned a job and I tried to do it. Right?
You hear both sides and you make up your own minds. How would that reasonable and articulable suspicion be developed? Through data mining programs or algorithms, or how do they decide?
Well, one bombing of a marathon would be enough.
No, but
I think what happens here is that FISA is related to agents of foreign powers historically, and now it's been expanded to sort of a broader sort of terrorism sort of investigation. And so I think what happens is our specific and articulable facts is a standard that's widely used for ECPA, and Mark is the guy who taught me ECPA, so he can tell us more about that. But part of the story.
Don't pin that on me, Peter.
What? No, I won't blame the teacher, but I'll just say that But what it means is that basically you need to be able to explain to a judge or somebody why we're looking at Jeff's record as opposed to sort of lots and lots of records. And if the reason is that Jeff had 23 phone calls to someone who's under investigation, that's easy. And so then, as you have fewer phone calls and fewer contacts, is it closely enough linked to meet the standard? So that's a normal part of.
As you're suggesting it, we really shouldn't be concerned, in your role as President Obama's lawyer, we shouldn't be concerned about the massive ongoing trolling because there's no search taking place, Susan. Lawyer Peter over there is saying that there actually is a specific an articulable suspicion standard, and the fact that the government is that the phone companies are turning over the data to the government shouldn't concern us.
Yeah, I hate to quote the statute.
Lawyer.
That's why I was trying to signal him. It's got the wrong standard. It's that you have to certify a statement of facts showing that there are reasonable grounds to believe that the tangible things sought are relevant. That's it. So reasonable grounds to believe the tangible things sought are relevant to an authorized investigation, to obtain foreign intelligence information. Okay, so that's why I want you guys to look this up. You can't believe these definitions and how broad they are. Not concerning a U.S. person, or to protect against international terrorism or clandestine intelligence activities. And I want to read the last part. Such things are presumptively relevant. So you don't even have to show relevance. They're presumptively relevant if the applicant shows in the statement of facts that they pertain to a foreign power. Foreign power is any foreign country, or an agent of a foreign power, anyone who lives in a foreign country or works or is associated with a foreign country. The activities of a suspected agent of a foreign power. Again, this is not just a spying foreign country. This is a foreign country. Or an individual in contact with or known to, okay? Do any of us talk to anybody in foreign countries? A suspected agent of a foreign power who is the subject of some such authorized investigation. So you have to look it up. It's unbelievably broad, and I think that to think that these things limit the investigations in a meaningful way is silly. And so I think that it's quite possible that the government believes that they are following the law. I think it's very, I'm sure that the law is unconstitutional because it doesn't impose meaningful limits on law enforcement surveillance authority. Nathan made a really important point about mission creep. This giant database that they've admitted to, and to be fair, we don't know for sure that it has location data in it, which is very significant constitutionally because the reporters have said it does, but the order that we saw just says telephony metadata. Now I'm going to assume it does because I've never seen the executive branch hold back on requests for information.
Is location data metadata, or is it
content?
Well,
you tell me.
I would think it has to be content.
No, metadata is a new word. I wrote an article in 1996 where I called it communication attributes. It's everything that's not contents. So there's no court decision interpreting metadata. It hasn't shown up in a statute before. I think we're using the word metadata to mean non-contents.
But wouldn't you, I think you have argued that Jones-like surveillance, where you're getting ongoing daily trolling for a month of metadata, should be the equivalent of content, that you're finding out so much that it really...
So yeah, that's... Okay, I just want to say one more point, which is that the data that they're storing over 7 years, they can access for, and this is in the minimization procedures, that information can be retained or disseminated for evidence of a crime that has been, is being, or is about to be committed. And it can be retained or disseminated for law enforcement purposes. So again, we're taking a lot of comfort in the fact that, we're only going to access this information, to catch the Boston bomber, okay? But it's a giant database that they can use for any law enforcement purposes. Okay, constitutionally, I've seen the executive branch officials, I think this was the DNI, and Obama himself say, hey, it's just telephone numbers dialed. And I've argued and continue to believe that that information is extremely intrusive, and that for us to rely on a 1979 decision of Smith versus Maryland that considered only the telephone numbers dialed, nothing else were they able to determine about the phone call because of the limitations of the technology. To rely on that case to say that anything other than content is not protected by the Constitution is a gigantic mistake. I think that that Smith versus Maryland again said telephone numbers dialed not protected. The courts have not really had a chance to consider much more revealing data, oftentimes much more revealing than the contents of communications. Again, we're waiting on the Fifth Circuit for location data, historical location data. I think the court should have a chance to think about this other information, duration of calls, who you called, and certainly over a period of time, when you have that information, you can learn about people's associates, their religious activities, their political connections, sources for journalists. Why do we think the AP, when they conducted the AP search, that they even had to conduct a new search? Why didn't they just go to this data? So I think it needs review, and I think it won't survive that review if the court does its job.
Great. We're going to go to PRISM in a moment, but Nathan, do you want to take issue with some of the...
Yeah, very quick point of disagreement with Susan on her reading of Section 215. The portion, remember, it's a two-step process. The portion of the statute that she read concerns the government's initial acquisition of the data, right? You can acquire the data, not look at it, but put it into the warehouse upon a showing of relevance. That, by the way, under FISA, that's the same standard you have in the criminal context under a grand jury subpoena. If you want to obtain a document, it's non-content, it may be content, but it's in the hands of a third party. So all you have to do is show relevance. Actually, I think the standard from the R Enterprises cases may be relevant. So you don't even actually have to show that it is, merely that there's a probability of relevance under the criminal law standard. So I'm comfortable with that standard under 215 for the initial acquisition. Now, where things get more complicated is in the question of what do you have to prove to put human eyes on the data, right? And that's where the reasonable suspicion standard comes in. It's not in the statute, right?
Where is it?
It's in the court order, according to the press.
As far as
it
we
must
can
be true.
As far as we can tell,
Yeah.
it's the FISA court
Yeah.
putting minimization requirements onto the scope of its orders.
On their own, not required by the statute?
That's what I've understood.
But not required by the statute.
But of course, we don't know. One of the problems is all these opinions are secret, so we don't know how they interpret minimization requirements.
But it's not required by the statute.
I have no reason to think it is.
I've never seen it in there. Okay.
What happens if you disobey a court order?
But,
Nothing good,
but
right?
how do we know it's in there?
We don't, right? And this is one of the problems we have whenever we debate classified intelligence programs, is that we can sit around and speculate.
Maybe the next leak will tell us.
Maybe the next leak. Maybe the next Snowden has a trick up his sleeve.
I think we've almost come to articulating the points of agreement and disagreement. My final question on Verizon is, you said it's just like a grand jury subpoena. And that's what James Comey, nominated to be the head of the CIA, said when he justified 215 to Congress in 2009. But it doesn't seem like one,
Right.
because a grand jury subpoena is for a particular criminal investigation. This is ongoing daily basis perspective of all data. So
Right.
it's not limited.
Right, and that I think is something we should worry about here. I'm not worried about the legal standard, right? Because the legal standard is comparable to what we have in the grand jury context. What I am worried about is the use of a tool in a different context from the one in which it was intended and understood to be used. And this goes back to a point I made in my opening observations. If we're going to have programmatic surveillance, we should clearly authorize it instead of trying to hide elephants in mouse holes. I'm not sure that 215 is the appropriate statutory vehicle for creating this sort of surveillance regime. There might be good reasons for having such a program. I'm not convinced. I might be, depending on the next leak, but I'm not currently convinced that 215 is the most appropriate vehicle for doing this.
Nathan, can I just get you to clarify? You're saying that the FBI is accumulating all this data, and then based on some self-imposed limits, they're asking the FISC for orders, again, self-imposed, and the FISC is imposing this requirement, not pursuant to any legislative requirement, that's making them limit themselves as to when they query the database for information. And you're basing that on something you've heard from the press. Am I right?
I believe what I read in the New York Times.
Okay, because I read in the paper that the NSA has full pipe access to Google and Facebook.
Should
I believe that?
Well, no, you shouldn't, because they walked it back. Because they in fact, was it Declan McCullough from CNET? From CNET, who said the press just misunderstood the deck of briefing slides.
The first day Washington Post story didn't hold up.
Okay,
Yeah.
but I actually find this much more incredible, actually, that the law enforcement would self-limit, and then that the FISC would
It's not self-limited. It's
because it's not required by the statute. It's
Well,
not required by the statute. Why would they
Courts
do it?
have statutory powers, and they have common law powers. And sometimes courts impose requirements on the government that are outgrowths of statutory mandates developed by Congress. Sometimes courts also impose orders and mandates on the executive branch in the exercise of their common law powers. If you defy either one, you are in contempt of court, and at best case scenario is your career is over. If it were merely a self-imposed executive branch constraint, I would have a lot more heartburn than I do. The fact that it is a court order issued by with the implicit threat of contempt sanctions gives me more comfort that the executive branch is going to comply with the court
I'd love
order.
to see it.
Last question.
I would too.
Last question on Verizon, because you talked about programmatic surveillance. Without that court order, would Verizon surveillance be consistent with the Fourth Amendment?
So when you say the surveillance, what part of the surveillance? The acquisition or the viewing of the data?
The viewing of data obtained on an ongoing daily basis, prospectively, of everyone.
Yeah, that's harder. It's a lot harder. So the constitutional standard is if it's non-content or if it's a document that's held by third parties, you have no reasonable expectation of privacy in it, and so the government's putting eyes on it doesn't count as a search. I'm going to have to disagree with Susan again on this. It's not just Smith v. Maryland that stands for this proposition, and it's not just telephony that the actual number is dialed. Previous cases, such as the Miller case, had involved bank records, which are very sensitive. Documents, tax preparation documents that you give to your accountant, which are very sensitive, perhaps even more sensitive than geolocation information is. And the court held in that series of cases that's as a third-party record, there's no reasonable expectation of privacy. So there is a lot of pressure being put on that 30-year-old doctrine, and I think there are maybe 2 or 3 law professors in the country who think that it's still good law, but it is good law right now. Right? So as a doctrinal matter, if I'm writing an answer on the bar exam, looking at the data is probably permissible under Smith v. Maryland. Will it continue to be after courts develop the doctrine and push it in new directions? Well, I guess we'll have to wait for the next leak of that, too.
That's great. That's very well said, and you really put your finger on the strongest and most aggressive administration defense, that the third-party doctrine, as articulated not only in Smith and Maryland, but all these other cases, says if I turn over data to a third party, I lose all expectation of privacy in it, and the government can do whatever it wants with it. And if, of course, that were applied in this way, it would be inconsistent with what the court held in the Jones GPS case, where the Obama administration.
I totally disagree with that, Jeff.
Well, let me finish the thought and then disagree with it. That basically the Obama administration took the position in the GPS case that I have no expectation of privacy in my movements in public because my geolocational data as well as the GPS data is stored in third-party databases. And the court unanimously rejected that on the grounds that, at least as Justice Alito said, the magnitude of the information and its aggregation can reveal so much about us that even though it's stored in third-party databases, it shouldn't be deemed waived. But Justice Sotomayor said we have to re-examine the third-party doctrine because if we don't, then there's no Fourth Amendment.
That was one vote.
Yeah.
But just quickly on 2 things. One, and you walked it back, Nathan, but the Miller case was 1976, and it really it should be limited to its facts, and some courts have recognized that it should be limited to its facts in some ways. The Warshak case, which is a Sixth Circuit case, found reasonable expectation of privacy in email despite the fact that it was stored with a third party, namely your ISP. So I don't think it's still good law in the sense that I think any court that understands how the Fourth Amendment needs to work in the modern age will apply it. I could be wrong. And one more thing, which is that the reason that the third-party records has trouble working here is because, and another reason that 215 could be unconstitutional, is they're not really getting records, as I think Mark alluded to. They're getting records on a rolling basis, which is really an end run around the provision they should be using. Because when you have a record stored and transferred as it's being created, you're really doing real-time surveillance. And the third-party records rule is supposed to apply to records. And actually in the Fifth Circuit case I worked on, the government asked for records to be created on a rolling basis for a similar reason. So it's a common practice.
Mark, you wanted to disagree before we go on to PRISM.
No, that's fine.
I was so persuasive. PRISM. I understand how this works even less than I understand how Verizon works. So who shall I ask to fill in the details? As I understand it from the press accounts, the government is giving targeted search terms to the internet companies that it believes with a 51% accuracy suggests that the searcher or data holder is a suspected foreign terrorist and not an American citizen. And based on these algorithmic requests, the data is being turned over, and then I don't know whether you need another order to actually identify the individual, but that may be completely wrong. Who wants to?
Can I do the statute?
Please, yeah. Oh, and tell us, in the course of doing the statute, tell us, first of all, what the 2006 amendments to FISA said. And
2008. You did already. You actually. Oh no, you did the 215 one.
So tell us what the 2008.
So what happened was the Attorney General and I think was concerned that with the prior requirement that the warrants specifically cite to a person and a facility that was to be surveilled, there was a concern that that wasn't going to adapt to modern technologies fast enough, and so Congress passed with the FISA Amendments Act of 2008 basically a blanket warrant procedure where the NSA and FBI could jointly authorize programmatic surveillance, and they could authorize procedures that didn't name a particular targeted person or a particular facility to target. So they just had to name basically a technique of surveillance where the targets in which persons reasonably believed to be located outside the U.S. and not U.S. persons would be targeted. And they were designed, again, to acquire this very broad category of information called foreign intelligence information. And the only real restriction was that U.S. persons may not be intentionally targeted. And again, foreign intelligence information relates to the actual or potential attack on the U.S. by a foreign power or an agent, sabotage or international terrorism, clandestine intelligence activities, or the national defense or security of the U.S., or conduct of foreign affairs of the U.S. So it's an extremely broad category. And so these broad, so under this authority, the NSA and FBI can authorize these joint sort of non-targeted programmatic warrants. And just a couple of things. When they are served on the electronic communication service provider, that person can tell only one other person who is the person who is necessary to be told to assist the operation. These orders are subject to whatever secrecy provisions the NSA and AG find necessary. Talk about contempt of court. If you tell anyone else, it's contempt of court. They're appealable only to the Foreign Intelligence Surveillance Court, which all proceedings which would be in secret. Those in turn are appealable to the appeal court of the Foreign Intelligence Surveillance Court, up to the Supreme Court, and there is some reporting, but it's mainly to the Intelligence Committee and then also to the judiciary, but I think those reportings, as we now found out, are classified, and they're very limited what gets reported, and you can check that for yourself. So that's the summary.
That's a great summary. Nathan, you have some disagreement with that.
Not so much a disagreement as much as an addition. So there's a very important safeguard that needs to be on the table as well, and that's minimization. So with programmatic surveillance, you're going to collect a lot of stuff, right? You're going to get information about Osama bin Laden calling Ayman al-Zawahiri down the street, right? A foreign-to-foreign communication involving non-U.S. persons. I don't really care if we suck up all that stuff, right? We should be, frankly. We're also going to get communications between Osama bin Laden in Afghanistan and Mohammed Atta in the United States, a non-United States person but here in the United States. And you might get accidentally, inadvertently, communications between an American abroad and an American here at home. So the trick is, how do you make sure that intelligence analysts are only focusing on the wheat and are ignoring the stuff that is irrelevant to their investigation and, moreover, raises very important privacy and civil liberties concerns? And the answer is minimization. Minimization is a set of rules. What are they? Again, they're classified. We don't really know. They're a set of rules proposed by the executive branch, reviewed by the FISA court, and then approved, signed off on, or modified by the FISA court that tells the government what to do with the accidentally collected information about innocent third parties. Do you delete it? Can you keep it in an archive database on the theory that it might become relevant at some point in the future if you develop more information that this person might be linked to international terrorism or whatever? I think the minimization rules do an awful lot of the work in this field in terms of protecting privacy values. Again, we're reducing the impediments on the front end. We're making it easier for the government to collect stuff on the front end. And the corresponding move then is to layer restrictions on the back end as to how you can use the information. And the minimization rules, I think, are a really critical part of the privacy protection puzzle here.
Okay, a very well-stated description of what the 2008 amendments seem to authorize. Now, more detail about how the PRISM program implements this. Mark, do you want to give us your understanding of what kind of algorithms are being used?
I have no understanding whatsoever, Jeff. I think we are all very much in the dark because the reporting on this, beginning with a fairly aggressive initial report, which, as others have pointed out, was walked back significantly over a period of days. I don't think we really know. Certainly, a number of the service providers who were named in those slides have forcefully denied various of the allegations. So, for instance, one of the complaints was that this was supposedly a direct pipe, and I don't know if all the providers, but certainly most of the major providers came out swinging in response to that. So I think there are things that if we take the walk back press stories at face value, there are things we can say are not happening, but I don't think we really do know how this particular surveillance is being implemented.
White House Counsel Swire, how might the algorithms work?
Right.
If you're trying to imagine how it works.
Right, I agree.
might
all
it
hard
be?
Facts are
hypotheticals.
hard to
Yes.
tell and I ever knew them. So I think part of the background here is to do the earlier FISA part. So FISA was 1978. It was after Watergate. It was part of the Privacy Act, Freedom of Information Act, part of a whole series of efforts to put the rule of law back into what was happening in the United States. And the first doctrine of FISA was we weren't going to go after U.S. persons. There was going to be this real protection all the way down the line. There was something later called UCIT 18 in the NSA, which was a big commandment. If you talk to anybody who's been around the NSA, they say, we can't touch U.S. persons. We have to black it out, minimize it, and all that. And that worked in a telephone world reasonably well. You could sort of tell most of the time. In an email world, who the heck is on the receiving end of emails? We have absolutely no idea. And so as a pervasive problem, there might have been communications between Nathan and me and then 5 other people, and they didn't know who was U.S. and who wasn't. And so there was a legitimate new problem that you often had an unknown zone between somebody who was sort of in the foreign intelligence, that was what we always used to do, and then we're in this huge gray area which was expanding. And so a relatively strong rationale for the 2008 amendments were, in that gray area, we don't stop doing anything. We have to go forward. And then we have to have some set of protections around that. Now, whether the minimization protections are good enough, whether the gray area tilted too much to surveil everything, those are things people can fight about. But there was a genuine problem for the intelligence people, and the 2008 law tried to do that. Now, I think the next step is, knowing that there's now going to be a big gray area and you're going to overreach and you don't always know who's a U.S. person or not, the next part is back to the programmatic part, which is how much is this just about Nathan or Jeff, or how much are we getting sort of everybody in Kandahar or whatever. And if it's everybody in Kandahar, we have some sympathy. My son's deploying to Kandahar next month. I'd like that to be as safe a place as possible, and there's a war zone. And so really heavy surveillance makes a lot of sense there. But the fact that some of those folks are communicating back by email to Washington, D.C., how you minimize, how you say we're going to stop problem if you're trying to solve that problem. And I think the minimization procedures are between a world where it is dangerous, there's foreign foes, there's wars, and they're using the same internet as all of us use every day. And really the big question is, how much do you look at the internet as a militarized foreign terrorist network, and how much do you look at it as not that? And if you have the militarized vision, you're just scared all the time that it's being used as a tool for very nefarious things.
Great. Final question before your questions. Nathan, if there were not adequate minimization requirements, is there a scenario under which the 2008 FISA amendments might be inconsistent with the Fourth Amendment?
So we're dealing with content here. So the default rule is you have to have a warrant before you conduct a search. There may be an exception, however, for foreign intelligence. The status of the so-called foreign intelligence exception to the Fourth Amendment's warrant requirement is uncontested. The D.C. Circuit in the 1970s said there is no such exception. I think every other court of appeals that considered it said yes, there is. And more recently, I think in 2008, the Foreign Intelligence Surveillance Court of Review issued its second ever opinion saying that the 2008 amendments to FISA are constitutional under a purported foreign intelligence exception to the warrant requirement. So I don't know actually what the answer to that question is. It depends on whether courts recognize such an exception, and if so, what's the scope of it? Does this exception encompass all surveillance for foreign intelligence purposes? Probably not, right? That's the Keith case from 1972. Well, actually, there's a footnote that says domestic intelligence, domestic-based national security threats are not covered. And then Katz has a footnote saying we're not addressing foreign intelligence either. That's a law professor's way of saying I don't know.
Always a good answer. Susan, you want to, bless you. Susan, you want to make the final argument for why the 2008 amendments are unconstitutional?
Well, yeah, just a couple of things. First of all, I think the minimization requirements in the statute are very weak. They say you need specific procedures reasonably designed to minimize acquisition, retention, and prevent the dissemination of non-publicly available information concerning unconsenting U.S. persons, consistent with the need of the United States to obtain, produce, and disseminate foreign intelligence information. So there's just a giant loophole there. I think that our National Security Administration, and I believe this is probably true of the Attorney General as well, believe that they are justified in amassing, and they've already done it, giant databases of content and attributes, and having those available for long periods of time to search for things that they feel they need to search for to protect us. And I think the problem is that amassed in all that information is a lot of protected speech, and that's too dangerous a tool for the executive branch to have, and that they can't be trusted, certainly under the procedures they have now, not to use it to abuse their authorities. And that the Supreme Court would agree that the Fourth Amendment requires much more procedural safeguards than are now in the law, and that they've said it before, and that's just our democracy depends on bringing up to date the Fourth Amendment's requirements as well as the executive authority. And it's a tough question how we're going to do it, but it hasn't been done yet.
Excellent. Wow, that was a good discussion. I now know much more than I did at the beginning, both about how these programs operate and about the best arguments for and against, whether they're authorized by statute and whether they're consistent with the Fourth Amendment. One of the many things I've gotten out of this discussion is we don't know enough about the legal arguments for how these programs operate to make a judgment about it, and I take from that the conclusion that the administration should release the memos that it is relying on to justify these programs legally. Ladies and gentlemen, we have about 20 minutes for your questions, so have at it. Wendy Kaminer.
Thank you. That really was excellent. I greatly appreciate the legal analysis. But I want to raise a question about how much the law matters when we're dealing with this vast public-private security industrial complex. I assume that as a practical matter, minimization procedures are about as relevant as the standard of relevancy. I assume that as a practical matter, that there's not really any difference between acquisition and analysis. That we're not just dealing with this identifiable core group of government officials in the executive branch. We're dealing with this vast network that's very hard to define. And very quickly, I want to make another comment about what I see as the social or cultural effects of all of this. I think right now the public, this is all quite theoretical to a lot of people because the surveillance is invisible and people aren't feeling the effects of it in their lives, and the concept of metadata is fairly arcane. The Boston bombing, which of course none of this did anything to deter, feels much more real to people. But it seems to me that when people become aware of this and what it means, that one possible consequence might be that we all start getting rationally paranoid about who we're in contact with, and that it puts an onus on all of us to investigate and maybe even inform on the people that we're in contact with and wondering who they're in contact with, and is this somehow going to catch us in this surveillance net?
Two good questions. Do minimization requirements matter, and is this changing the way we interact as citizens in a free society? Do minimization requirements matter, Nathan?
I think they do. If they were self-imposed by the executive branch, they would matter less. The fact that they're imposed with the backing of a FISA court, I think, makes it matter a bit more. What are they? We don't know, so we're not really in a position to say whether or not they actually do an effective job of filtering out the innocent third-party data that we all want to see filtered out. But if they were simply guidelines that the government could choose to follow in its discretion, that would be one thing. The fact that the procedures are reviewed by Article III judges serving on the FISA court and then enforced by Article III judges on the FISA court is a point in favor of their effectiveness. But again, we can't really assess how effective they are, not knowing anything about their content.
Good. And
Jeff, can I just jump in there?
Please,
Because
sure.
one question I have about this is whether there's any reason, and I'm not directing this specifically at Nathan, although he may have a ready answer for it, why the minimization procedures themselves could not be made public. One can imagine a situation in which the procedures could be disclosed without describing the particular collection methodologies, sources and methods wouldn't necessarily have to be revealed in order to say, well, once you have some set of information, how is it you're going to decide what you can and cannot do with that as a downstream intelligence community consumer?
Can I just jump in? I mean,
No, let him.
Oh, sorry, Nathan.
I want
Nathan,
to. Don't let him off the hook here.
Nathan, why not make him
I
public?
thought you said it wasn't directed at me.
Why can't they be public, Nathan?
Covered programmatically.
Do you mind? It's not a bad question. Why not release the memos?
Yeah, I'm trying to think of. So
Well, no, I'm not saying the memos.
No,
I'm
the
just saying what the
minimization.
procedures
description,
themselves.
right? You could release a redacted version of the memos, or a thumbnail sketch description of what, in principle, we do without getting into the details. Yeah, sure. I think we could do that. Or the the legal rationale for why the minimization procedures make the search reasonable for Fourth Amendment purposes. I think you could release things like that in a way that keeps intelligence sources and methods still behind the veil of secrecy, but allows for transparency and public debate.
Great.
Let me just say, the FISA court, which you guys have more faith in than I do, or Nathan does at least, already issued a decision in October of 2011 saying that the government was not exercising its 702 authority consistently with the spirit of the law in at least one instance, and that the minimization procedures were inadequate in at least one instance. And the Electronic Frontier Foundation has had a really difficult time and has yet been unsuccessful in getting access to that opinion. And the only way we know about it is because Senator Wyden was able to get that fact unclassified, and I don't know how he did it, and it's on his website. And he's been getting the runaround from the Department of Justice and from the FISC in terms of how to get that very opinion released. So, I just went to a conference in which Magistrate Judge Smith gave a talk and said, judges are supposed to operate in public. And that's how it's supposed to work, and they're supposed to issue decisions in public, and that's what due process means, and that's how the system's supposed to work. So I'm not even sure. I'm certainly not sure why we should be relying so much on this FISC that can't issue decisions in public, when we can't get access to their opinions. And then the last thing, I think there's reason not even to believe that just because something is illegal, the executive branch isn't going to do it when it comes to surveillance. I don't know if that's a radical thought, but I think that history proves it not to be very radical.
Yes, sir.
I had a quick question with regards to standing. Hypothetically, either I'm a lawyer with foreign clients who, are potentially accused of sketchy business, or I'm just a Verizon customer and I think maybe I'm being surveilled. And I'm seeing a standing question, and I want to know how it's going forward. What I mean by this, if I say, Nathan, what's the methodology they're using? You'll say it's classified, and you'll be right. So I can't look for the methodology. So I go to court and say, but I think I'm being surveilled, and now it's suddenly speculative because out of harm, causation, or redressability, I can't prove harm. So I have no standing. So I can't ever find out if I'm being surveilled unless they slip up and I see them surveil me and catch them. That seems to me like a huge problem going forward in monitoring. What resolution is there to that?
It's a
Yeah,
great
so this is-
question. Can I get
Yeah, please,
specifically?
please.
You know, it's a wonderful question. The Supreme Court in the Clapper
Clapper,
case
yeah.
said no standing. The ACLU has refiled or its suit, or reinitiated its suit against the latest programs. Why should the standing come out any differently?
Yeah, right. So sometimes you can trust government incompetence to make your case easier. But you're quite right. Other than the government tipping its hand and mistakenly informing you that you're under surveillance, it's difficult to imagine a scenario where you could demonstrate to the satisfaction of standing doctrine that you have an actual and imminent injury that is concrete and cognizable, rather than something that's merely speculative, right? So what are we talking about here? What we're actually talking about is a second round of judicial review. Right. There's already been a prior There's been a prior round of judicial review afforded to the ISP, in which the ISP has been able to say we shouldn't be subject to this order because it's too burdensome, whatever. The interests of the ISP and you as a subscriber to the ISP are similar, but they're different. Right. Both you as the subscriber and the ISP have an interest in the government not snooping around. You because it violates your privacy. The ISP because it's burdensome and costs money. Right. So there's something of a congruity between the interests of the subscriber and the ISP, and maybe the ISP has a sufficiently strong interest to resist the government in a way that provides privacy benefits to the subscriber. That's an account of the initial round of surveillance, court approval for the surveillance. Now the question becomes, do we need a second round of judicial review, now brought by not by the ISP, but by the subscriber directly? Standing doctrine is an obstacle, as you point out, to that second round of review, and it's problematic from the standpoint of an individual who thinks he's under surveillance but has to prove it to metaphysical certainty before he can get inside the courthouse door. And right, that's harmful from a privacy standpoint. I want to suggest, however, that the harm is not as significant as it would have been if there had been no prior judicial review. Right, the prior judicial review is not a perfect substitute for allowing you as the subscriber to challenge the surveillance later on, but it's better than nothing. Right?
Yeah, I just want to really quickly, first of all, with these programs we're talking about, the ISPs cannot mount a meaningful challenge because the challenge is very circumscribed. It's only to the FISC. It's only that the orders don't meet these very low requirements that they have to meet.
There's an article in the New York Times today on this precise topic.
And the ISPs have full immunity. They're subject to contempt if they don't comply. So I just think that under these programs, the ISPs offer any kind of a meaningful check is very silly. I think not to say you're being silly, Nathan. And under the
that's generous.
Yeah. Not to say it. And under ECPA.
That's also generous.
Under ECPA, I think there's more of an argument and more of a history under the Electronic Communications Privacy Act that the ISPs have shown some resistance. And I wish that David Lieber were here from Google, because Richard Salgado of Google has really pushed back and required warrants in cases where they weren't required. And to give us shout out, some of the sponsors have joined in the Digital Due Process Coalition to push for meaningful reform, and that's great. That's Facebook, Microsoft, Google. So I think providers in the law enforcement context can sometimes push back and have chosen to, and some haven't. But in the foreign intelligence context, no way do they provide a meaningful check.
Except in the NSL context, where several New York-based ISPs successfully litigated constitutional challenges to requests under national security letter authorizations to turn over customer information. Right?
Except they're still subject in pending appeal.
Yeah. And they won in the Second Circuit, so that's a pretty important example.
Only
of
about
pushback,
gag, not about compliance. Sorry.
Notice also that it's a constitutional objection. Not we haven't dotted the I's and crossed the T's on the FBI application. This is a substantive constitutional objection alleging First Amendment, Fourth Amendment allegations. And there's no reason to think that the FISA court doesn't entertain the same sorts of constitutional objections. In fact, we know that they do. Right, because the 2008 FISA Court of Review, the appellate version of the FISA Court, expressly engaged the constitutional question whether the 2008 amendments to the FISA statute satisfied the Fourth Amendment, the particularity requirement, the reasonableness requirement, the warrant requirement, and so on. This isn't a paper tiger. This is a court that engages in meaningful constitutional review.
But you're talking about the review of the principal purpose language, right? Not the 2008 programmatic.
No, there was a constitutional challenge to the substance of the statute. That was brought up in the context of a 2008 legislation order directed to an ISP, and that was a vehicle that the ISP was able to use to challenge not just the the details of the order, but also the underlying statute upon which the order was based, right? That's a constitutional adjudication. These are Article III judges. They're not limited to being paper tigers and administrative bureaucrats that rubber stamp applications. They actually do constitutional review.
Then we
They're
should
judges.
see their opinion. Then we should see their opinions.
And we should, yes.
Gentleman in the back.
I just want to press on the idea that we should feel comfortable that that once you do a search, once someone looks at it as a real person, then there's minimization. Because doesn't that create an environment in which you want to put more and more and more on computer processing? So you can imagine you had something like Watson, and you ask Watson, who are the likely terrorists here? Mm-hmm. And so all that is done, and a list comes through and says, here are the people we think are connected into terrorism based on the analysis. Right. And then it goes to a human. All that, on the version of the doctrine, is done without conducting a search. So I think we need to think about how that doctrine works with modern technology. We're just kind of baiting the NSA into getting better with artificial intelligence, and they're already pretty good at that.
Algorithms and the Fourth Amendment. Mark, any thoughts on that?
Well, there's certainly some exponents of that view. Judge Posner on the Seventh Circuit has argued repeatedly that if a human being doesn't look at your stuff, if it's just a computer reviewing the data, there's no search. I think that's fairly problematic. I think there is a privacy harm when communications, contents of communications are intercepted. If the police set up a tape recorder and tape record all my phone calls, I still sustain a privacy harm, even if they have not yet gotten around to listening to the tape.
Just a word that hasn't been used related to the period is chilling effect. It's remarkable because that's, I think, part of what Mark's saying. If you know every word is being tape recorded, you act differently. Tape is still used, but it's being recorded, you act differently. And that's part of freedom of association being chilled or talking to the press being chilled, and that's certainly part of what's going on.
Say one more beat about that, Peter, because it goes back to Wendy's second question. Should people care, or not should people? Some people on this panel think they should. Do people care? Are people actually being chilled? Nothing to hide, nothing to fear. Most Americans, according to the latest polls, support both of these programs. You're a privacy advocate. In practice, do you think people actually are chilled by the knowledge that algorithms are getting their data?
Whatever, I've moved from White House lawyer to privacy advocate.
Yes. Got to be on your toes in this business. You can join Actors Equity as well.
But I think the polling's importantly more nuanced. So the second poll that came from CBS said, do you think ordinary Americans' phone calls should be looked at? And 3/4 said no. And if that's what Verizon is, that's a much more interesting polling result than saying, are you willing to take a little safety and give up a little privacy, which is what the first poll said. So I'm not sure I have a lot more on the rest.
Okay. Yes, ma'am.
As a former Article III judge, I can tell you that your faith in the FISA court is dramatically misplaced.
At least you didn't call me silly.
Right. For two reasons. One is, after having taught Fourth Amendment law and having practiced it, the Fourth Amendment frameworks have been substantially diluted in the ordinary police case. One can only imagine what the dilution is in a national security setting. Two, the people who make it on the FISA court, who are appointed to the FISA court, are not judges like me. Enough said.
In the front row.
Thank you. I have a question just to help with my understanding of how it would work. If, let's say that hypothetically you reach a stage where through the use of this surveillance, you now have a person who is being prosecuted for whatever circumstance. And in court, that particular court would then be faced with asking, in the same manner that you would have to ask about probable cause of any search, whether or not these minimization requirements were met in the use of this particular data towards this person being indicted. Would the court then be able to review directly these classified minimization requirements? And if it did, would then those requirements become a matter of public record? And if not, how would it not happen?
That Mark would be a great person on that.
Yeah.
It's a hard question. Yeah, well, there's a statute called ECPA, Susan just mentioned, Classified Information Procedures Act, but that's really about how evidence gets admitted without disclosing particular collection techniques. I think the question here is about how do you litigate a suppression motion against these kinds of collections? And I don't think we really have a very good answer to that.
Hard question without a clear answer. That's what the special answer here. Sir, on the end there.
Yeah. You want to invite me? Okay.
The NSA is listening. Please speak into the microphone.
I have a quick Verizon question for anybody and a quick prison question. The quick Verizon question is the way Feinstein has explained a reasonable articulable suspicion, it sounds as if it is simply the intelligence people having found an American phone number on the laptop of the guy in Yemen, are then about to query the black box, and they ask themselves, do I have a reasonable articulable suspicion that this is a useful exercise? I didn't get the impression from her, maybe I was wrong, that they then run to the FISA court. They simply conduct this kind of internal analysis, and the question and the answer are almost the same. We found this number. Of course, it's worth putting this number into the search engine. And at that point, when we pull up all of these algorithmically connected conversations, if we want to look at the content of the American's phone call, well, yes, then we have to go back to the FISA court on probable cause to get a warrant. Is that how everybody understands it? And the second quick question.
Let's do that one first.
Those are good questions. I'll stop that.
But I actually think we have some answers. So I think if I were putting my White House lawyer back on, these are for 90 days. The court has them for a short time, presumably, so they can make sure the procedures are being followed. They're supposed to be followed. And the government, my guess is, has to say something about how we're following these rules to the Article 3 judge on pain of contempt if they're lying. So there's supposed to be some way to sort of say we're really following the rules.
But I don't think they're going on an order by order, on an inquiry by inquiry basis. And I've been reading everything I can find, and I haven't seen that. So Nathan will respond in a sec, but I haven't seen it, and I can't imagine the court would want to hear about it. And the other thing is, this, it's a very, very easy standard to meet. So you're right. Someone called someone, I'm going to look. And historically, the law enforcement uses this idea of community of interest, so if you're calling someone, we get to find out what it is, and if that person's calling someone, that's interesting to us. So it's a very common theory that they're using there.
We don't know. This is one of the many things we don't know about the programs yet. Do you have to go back to the court to demonstrate reasonable suspicion, or is it a certification thing? We just don't know yet.
The second question will have to wait because we are out of time. I am supposed to announce that after this session, there is a networking luncheon, which sounds much more menacing followed by something that is not menacing at all, which is a featured address by Justice Stevens. Ladies and gentlemen, this is exactly the kind of debate that I'm proud to conduct as head of the National Constitution Center. All sides have been ventilated, and we're all now much better.